Hi friends, today I am going to discuss about the topic 42nd Constitutional Amendment Act 1976. It is also called as mini constitution. Why it is called mini constitution? Due to the important and large number of changes made by it in various parts of the constitution, including the preamble. So it is called as mini constitution. 42nd Constitutional Amendment Act is most controversial amendment in history. It is enacted during the period of Indira Gandhi government. The next government, Janata government headed by Morarji Desai, sought to undo many changes introduced in the constitution by the 42nd Constitutional Amendment Act 1976 through the 43rd Amendment Act 1977 and 44th Amendment Act 1978. What are those changes? First one, added three new words, that is socialist, secular and integrity in the preamble. Preamble has been amended only once by the 42nd Constitutional Amendment Act 1976, which added three new words, socialist, secular and integrity, and changed the description of India from sovereign democratic republic to a sovereign socialist, secular, democratic and republic, and also changed the words unity of the nation to a unity and integrity of the nation. Next one, added fundamental duties, Article 51A of the Citizens, Part 4A. The original constitution did not provide fundamental duties of the citizens. These were added during the operation of internal emergency 1975 to 1977 by the Constitutional Amendment Act 1976 on the recommendation of the Swaran Singh Committee. Most provisions of the amendment came into effect on 3rd January 1977. Others were enforced from 1st February and Session 27 came into force on 1st April 1977. The fundamental duties in the Indian Constitution inspired by the USSR. 86th Constitutional Amendment Act of 2002 added one more fundamental duty. Next one, added four new directive principles. What is the aim of directive principles? The aim of DPSP is to establish a welfare state and providing social and economic justice. The 42nd Constitutional Amendment Act of 1976 added four new directive principles to the original list. They are C. To secure opportunities for healthy development of children, that is Article 39. To promote equal justice and to provide free legal aid to the poor, that is Article 39A. Next one, to take steps to secure the participation of workers in the management of industries, that is Article 43A. Next one, to protect and improve the environment and to safeguard the forests and wildlife, that is Article number 48A. These four TPSPs added through the 42nd Constitutional Amendment Act. DPSPs borrowed from the Irish Constitution. Next one, the 42nd Constitutional Amendment Act transferred five subjects to concurrent list from state list, that is education, forests, weights and measures, and protection of wild animals and birds, and next administration of justice. These five subjects transferred from state list to concurrent list. Next one, facilitated the proclamation of national emergency in a part of the territory of India. The 42nd Constitutional Amendment Act of 1976 enabled the President to limit the operation of a national emergency to a specified part of India. A proclamation of national emergency may be applicable to the entire country or only part of it. Next one, extended the one-time duration of the president rule in a state from 6 months to 1 year. The 42nd Constitutional Amendment Act of 1976 had raised the period of 6 months to 1 year. Once approved by both houses of parliament, the proclamation of president rule could continue for 1 year. But the 44th Amendment Act of 1978 again reduced the period to 6 months. Next one made the president bound by the advice of the cabinet. The 42nd Constitutional Amendment Act of 1976 made the President bound by the advice of the Council of Ministers headed by the Prime Minister. It is enacted by the Indira Gandhi government. Next one, the 42nd Constitutional Amendment Act of 1976 proposed the allocation of seats in the Lok Sabha to the states and the division of each state into territorial constituencies till the year 2000 at the 1971 level. It is the population controlling measure. After every census, a readjustment is to be made in allocation of seats in the Lok Sabha to the states and division of each state into territorial constituencies. This is extended for another 25 years up to 2026 by the 84th Amendment Act of 2001 with the same objective of population limiting measure. Next one, it added a new part 14A to the constitution, it dealing with administrative tribunals and tribunals for other matters. The original constitution did not contain provisions with respect to tribunals. The 42nd Constitutional Amendment Act added a new part 14A to the constitution. The tribunals consist of two articles. Article 323A dealing with administrative tribunals and Article 323B dealing with tribunals for other matters. Next one, it curtailed the power of judicial review and writ jurisdiction of Supreme Court and High Courts. It means it is limiting the power of judicial review and writ jurisdiction of Supreme Court and High Courts. What is judicial review? It is the power of a court of the country to examine the actions of legislative, executive and administrative arms of the government and to determine the actions are consistent with the constitution. If not, those laws are declared unconstitutional, moreover null and void. Next one, provided that the laws made for the implementation of directive principles cannot be declared invalid by the courts on the ground of violation of some fundamental rights. It means the 42nd Constitutional Amendment Act 1976 extended the scope of directive principles over the fundamental rights conferred by Articles 14, 19 and 31. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills case 1980. It means that the directive principles were once again made subordinate to the fundamental rights. But the fundamental rights conferred by Article 14 and Article 19 were accepted as a subordinate to the fundamental rights. Next one, made the constitutional amendment beyond judicial scrutiny. Next one, raised the tenure of Lok Sabha and state legislative assemblies from 5 to 6 years. Next one, it empowered the parliament to make laws to deal with anti-national activities and such laws are to take precedence over fundamental rights. The next changes empowered the center to deploy its armed forces in any state to deal with a grave situation of law and order. Next one, did away with the requirement of quorum in the parliament and the state legislators. What is quorum? Quorum is the minimum number of members required to be present in the house before it can transact any business. It is 1/10 of total number of members in each house including the presiding officer. It means that there must be at least 55 members present in Lok Sabha and 25 members present in Rajya Sabha if any business needed to be conducted. If there is no quorum, it is the duty of the presiding officer either to adjourn the house or to suspend the meeting until there is a quorum. Next one, empower the parliament to decide from time to time the rights and privileges of its members and committees. Next one, provided for the creation of All India Judicial Service. Though the 42nd Constitution Amendment Act of 1976 made the provision for the creation of All India Judicial Service, no such law has been made so far. Next one, shortened the procedure for disciplinary action by taking away the right of civil servant to make representation at the second stage after the inquiry, that is on the penalty proposed. These are the changes made by the 42nd Constitutional Amendment Act. Thank you, friends. If you like my presentation, please like and subscribe to my channel. Thank you.